Hi, I'm Greg Dell with Dell Disability Lawyers, joined today by attorney Stephen Jessup, and we're looking forward to talking about one of Stephen's recently resolved cases against New York Life, which was formerly Cigna. This case is extremely interesting because it was a former Cigna employee, so it just goes to show that Cigna clearly doesn't discriminate whether it's their own or anybody else. But in these videos, Steve, as you know, we talk about why they denied our client, what you were able to do to help get them paid again, and then provide some tips that might help people to either avoid denial or win their appeal if they do find themselves denied. So let's hear a little bit about your case.
Yeah, so my client was a customer service rep, working for Cigna companies. So when she first applied for disability and everything, the transition and the purchasing by New York Life was already in place, but they were still going under the Cigna letterhead. So she was approved initially, severe spinal stenosis. I mean, the objective findings on MRI were rather strong. They determined, she couldn't perform the duties of her sedentary occupation, and they paid her for just about a year when she got a denial letter. And in the denial, they were basing it on an attending physician statement completed by her doctor that gave her a gamut of restrictions and limitations. Some that put her into light duty ability, some that precluded her from sedentary work. One of the biggest ones too is he had indicated on the APS that she has to take certain levels of narcotic medications, that she would be limited from driving and working on account of the dosage of the medications. Well, New York Life in this situation has the file reviewed, and their doctor is, in the denial letter agrees with her treating physician that she would have the ability to, perform at a sedentary level. So this doctor, and it's something we see a lot, they focus on what's going to help their position and ignore a lot of the stuff that's helpful to the insured. So they just came back and said, we think that you can work at a sedentary level, and that's it for you. When she did contact us, that was one of the biggest things. And it's not the first time we've represented someone who works for the company who also insures their policy. But she was really, hurt and surprised, understandably so. But I think she, really quickly, came to realize that they don't care. And I think if there's a big takeaway from this is that an insurance company, like you said, they don't care if you work for them or whatever the case may be. They're going to treat you the same way they treat everyone else. They have their protocols to try to find any reason to deny.
And you said it was spinal stenosis. Was it a neck or back issue?
It was lumbar. It was lumbar.
And she had objective evidence of her condition. And why is that important in these cases to have objective evidence of a back condition?
Because if there's no objective medical evidence, be MRIs or sometimes nerve and conduction studies and EMGs, they're going to really play this game of, well, it's all subjective, right? You're saying this and we don't know if we can take it at face value, or even if there's minimal results, well, we don't think you should be experiencing this level of pain, situation here. So having strong MRI evidence where you can point to, hey, listen, here is a reason why she's probably making the complaints she's saying, and why she can't sit for these periods of time or stand for a certain period of time without really needing to take lengthy breaks on account of it. So like most of these claims, it's really going to come down to the strength of the medical, and the more objective medical evidence you can have, the better.
Okay, so once you had the opportunity to review the claim file, which is what you request from New York Life after they deny a claim, what was your strategy moving forward to win the appeal?
Yeah, I think the biggest first piece was really the internal review by their doctor, because in the denial letter they make it seem like her doctor sold her up the river. Right, so once I saw the attending physician statement that he had completed, it was a much different story. And even the report done by their own in-house doctor, it was interesting. One of the things we argued very strongly in this appeal was their in-house doctor was saying, well, basically, I think she could do sedentary as long as she has, and it was like 4 or 5 accommodations. One of the arguments we had, there's nothing in the policy about you're not disabled if there's, accommodations. Like they were trying to say, oh yeah, she could do this if X, Y, and Z is possible. Well, I use their national economy standard of occupation against them, saying, well, in the national economy, these types of accommodations can't be put in place for her type of job because it's going to be during set hours, so she can't take a break for 2 hours and then work into the evening type thing. So it was really starting to attack the actual internal report done, and then seeing where we could build upon, the information to support it. That led us to a functional capacity evaluation. In functional capacity evaluation we've discussed is testing that's usually done with the physical therapist or maybe with the physiatrist, and it's geared towards the Department of Labor standards for work, sedentary, light, medium, heavy. And her doctor is pretty good because that FCE the restrictions and limitations were very close to what the doctor had put in the attending physician statement. Yes, she had some abilities that would push her into light duty, but overall she didn't have the capacity for full-time sedentary work. So that was one of the pieces, and then we really took that along with New York Life's internal doctor report and got it back over to her doctor, and her doctor was not too happy about the way his opinions were twisted, and he wrote us a very, very strong response letter. And then with that, we did our own vocational assessment as well, and we submitted the appeal.
And now that you mentioned a vocational assessment, what does that mean?
So we wanted to really kind of hone in on the job. Yes, they did their own, and they just kind of did the basic ones from the Dictionary of Occupational Titles and stuff like that. But we had our own vocational assessment that really took a look at what the restrictions, limitations we had. Because if they're trying to make this argument that, if she can work with accommodations, our vocational assessment was really showing that those types of accommodations aren't something that's realistic under this idea of a national economy standard in the workplace for her particular job.
So in terms of for people who are watching this video and trying to figure out how to do an appeal, it sounds like you not only relying on her own treating doctors who had to provide clarification, which was super important, and obviously you reached out to him and worked with the doctor to do that, but you also had to use 2 other outside experts, which are tools or types of evidence that you obtain that are not necessarily available to people who are submitting these types of appeals. So it's really important for people to realize that you had to help find someone who could do a functional capacity exam, which is not easy to do, and then locating these vocational experts and then guiding them as to honing in on exactly what they need to address in the appeal, taking into consideration the policy language, also requires a lot of guidance. And that makes it very difficult for someone to do this on their own. Yeah. Yet, Cigna or New York Life often tells people, well, just send us a reason why you disagree, and we'll review it again by someone else. Why is it dangerous or not recommended for somebody to just go ahead and write their own reasons as to why they think the appeal should be, the decision should be reversed and their benefits should be granted?
So, especially now in this particular carrier, because it was Cigna, now it's New York Life, but the actual underwriting insurance company is Life Insurance Company in North America. Prior to New York Life purchasing, these policies, they allowed for 2 levels of appeal. One mandatory, one voluntary. The rules were a little different for the second one, but you at least had a second opportunity. Now you only have one shot, just like most insurance companies. So if you just submit a 1-page, appeal letter, which we've seen plenty of times, and they go, okay, well, and 2 weeks later we reviewed all the information, we're upholding our decision. Your claim file's closed. No new information can be brought into your record for a judge to later consider in court. So you've just been precluded from any additional arguments. And when an insurance company, when you get in court, has the ability to, the protection of this arbitrary and capricious standard of review, you as a plaintiff would have to show, 1, you're disabled, which generally, most cases, there's enough medical evidence to be able to say this person's disabled, but it's that second step. Did, in this case, New York Life, act arbitrary and capricious, or did they have a reasonable basis to deny the claim? That's a very low threshold for them to meet. So if you submit a very quick turnaround appeal and you don't get this additional information and you're precluded from arguing it later, you're only increasing their odds of winning under that standard. And also with this client we were talking before we started filming, when you say a lot of people who submit, and a lot of people do submit, and then it gets dragged on and dragged on and dragged on. They were doing that with this case. It was always some excuse letter. They didn't take their 45-day extension formally, and they kept talking about, we need another 30 days. And strangely enough, we submit the appeal. We get confirmation of receipt of the appeal, and it's going to be assigned to a claims rep. 45 days is almost up. And then we get another letter that because I said, hey, do me a favor, call over and see what's going on with this. And we learned that, the file got sent to the wrong department. It's just been sitting there for 45 days. Nothing's going on. It's over in the right hands of the right person now. They're going to start their review. Well, we know those 45-day deadlines, and then if the extension, those are very important dates. So under her particular situation, since we didn't submit any additional information that would toll that period, I didn't want to sit and potentially wait another, 30, 45 days. And I know that we can secure more favorable standard review, that idea, are you disabled in court? So we filed a lawsuit immediately. We had rights for their failure to render a timely decision. We filed the lawsuit. I wrote back to the claims representative. I'm like, you can certainly, continue your review. Here's a copy of the complaint we filed because you guys dropped the ball. And in this case, not surprisingly, like a week later, we got confirmation that her claim was being reinstated. But for filing that lawsuit, it could still be getting dragged on, or they could be building up lots of additional evidence to deny her and just strengthen their position in court as well.
Right, so another great advantage because you brought the firepower and said, look, you guys can screw around, we're suing you, we're not waiting around for you to take your time. And it's critical for the client as well because the client's sitting there for months. This client had already been waiting for 6-7 months
long time.
with no benefits. So, and it's sad that New York Life gets the file and then they're like, oh, sorry, we sent it to the wrong person. But luckily you filed your complaint and within 10 days they reversed the decision.
Reversed decision.
And then the lawsuit was obviously dismissed and then they reimbursed for your filing costs so the client didn't have to come out of pocket for that, which was great. Well, congratulations on a great outcome against New York Life, and I'm sure the former employee of Cigna, now New York Life, really appreciates it. But you are in an own occupation definition
Correct.
of disability, and it sounds usually after 24 months the definition switches to any occupation. However, in cases where you're dealing with a sedentary type occupation, it's usually not as challenging when the change of definition is going to come because of the fact that you're going from one sedentary occupation to another sedentary occupation. However, you know that someone else is going to review the file again at New York Life and there could be another battle on the horizon because they're going to look at it again totally differently. So what are you advising the client to do to prepare for the change of definition?
Now that she has the funds and everything coming back in, I said you need to start getting to the doctor again because in preparing for that, like you said, if she couldn't do a sedentary job before, why could she do one now? The nature of her condition, is not going to get better. Maybe with some surgical intervention, if that were an option, which right now it isn't. It's only expected to get worse because the spine's going to deteriorate. So the big concern would be we received the updated medical records and we don't really see much, so you must have improved. Our doctors now think you can do sedentary work. So it's very important for her, to get back in the doctor. Thankfully in her situation, she has a doctor who's very supportive, very thorough in documentation. So it's a matter of positioning her to set her up for success there. To overcome that hurdle, but her and I have already discussed. Yes, we've won this battle, but there's still going to be many that lay ahead of us.
All right, great. So thank you again and congratulations. If you're someone out there who has a New York Life long-term disability policy or formerly a Cigna long-term disability policy, feel free to reach out to Stephen or myself or any of our long-term disability lawyers. No matter where you live in the country, we're always available to provide you with a free initial phone consultation. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process. And when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search. Plus, we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.